Rule 26A, that's a real big rule. Actually, 26 has a couple of different ones. Rule 26A is required disclosures. And this really changes the way e-discovery or discovery has been done, because we're used to the adversarial system. Well, with e-discovery, they want you to turn the information over just out of your own volition and free will, which I know everybody doesn't do. But this, again, changes the whole sort of framework of our litigation system. And you must provide other parties with a description or copies of all ESI that you wish to bring into trial. And this also expands what can be discovered from email to Word documents, voicemail, instant messaging, backup tapes, database files, and more. 26F, that's obviously a huge rule. The meet and confer, really early case assessment is huge. You've got to map this strategy right at the beginning. 26F, the meet and confer, requires all parties to sit down together before discovery to agree on some form of production regarding ESI. So the form of production is key here. Native files, PDFs, metadata intact. Again, the litigation hold is going to be key as well at this meet and confer to make sure that you're not destroying crucial evidence. And early case planning, it's not just something the court wants you to do. Obviously, if you put the time in early, it's going to help you out in so many different ways, being able to locate the information, doing efficient keyword searches, knowing how to go after that information. It's going to save you and the client a lot of time and money. 26B2B, the undue cost or burden clause. This sets up a two-tier discovery for accessible and inaccessible data. Now, it provides procedures for cost shifting on inaccessible data. Basically, if the discovery of electronically stored information is not reasonably accessible due to the undue cost or burden, then the party would not have to provide ESI from this source. And this considers the needs of the case, the amount of the controversy, the party's resources, the importance of the issues at stake in the action, and then lastly, the importance of the discovery in resolving issues. So you might want that information, but you might have to work for it, and the judge might make you pay for it. Another main part of 26B is 26B5. Those are the clawback provisions, which basically clarifies procedures when privileged ESI is inadvertently produced. So this allows the clawback of privileged information. Obviously, there's still huge drawbacks associated with this. You don't want to just be giving up your privileged information. And again, this is why early case assessment is so huge, because you have to figure out what's privileged, what's not, in just stacks and stacks of electronic documents. Rule 34B, form of production, has also been huge. This establishes the protocols of how records are supposed to be produced. And if counsel fails to state a production format, the responding party should produce the documents in the format in which the information is ordinarily maintained or in electronically searchable form. And this also relates to some different metadata issues as well. You have to state, if you want the files in native format, you definitely want the metadata intact, because that's going to give you the most information possible. Lastly, Rule 37F is a safe harbor. This precludes federal courts from imposing discovery sanctions against the party for failing to produce ESI. The standard, it's definitely, you can't just, oh, the dog ate my laptop, I lost all the information. The data has to be lost or overwritten in the normal course of business. And that is something to do with the Zublake decision. Some say it kind of guts that decision. But this is very important, again, with the litigation holds and data destruction policies, because you have to make sure that you have those in place. If evidence gets destroyed and you don't have these data destruction policies, you're going to be in deep doo-doo. So lastly, our fourth main point we just want to touch on would be some practice points, the last take-home. So the first of which is preserve your client's ESI. You don't want to spoil that, because you can face sanctions from the court. It might greatly handicap you at trial or in settlement as well. Second point, access and utilize the opposing side's electronically stored information. This is where your battle is going to be lost or won. Use pretrial conferences to your advantage. Again, early case assessment, early case planning, as much as you can do up front, build that solid foundation. It's going to help you to construct a really beautiful house after. Carefully draft discovery requests, and especially with like keyword searching, different things having to do with native production format. Be specific, don't be vague. The more gray area or area you leave for interpretation, the more it can come and bite you in the ass. Production formats are crucial. That's our fifth point, and we've touched on that greatly. With metadata, native data production, you want that with the most amount of information possible if you're trying to seek it, and if you are the party that's being sought for discovery, you want to limit the information that gets out there. Sixth, don't hesitate to ask the assistance of the court. Don't be a dummy and think you know everything, and that's only going to piss the judge off if you screw something off. 7, carefully gauge the costs. I mean, you can go out and discover all volume of information you want, but it's going to cost you in the end. And the 8th point, don't piss the judge off. Don't try to play hide the ball. If you don't know something again, ask for the assistance of the court. You know, attorneys, I think, have the in the back of their mind when they graduate from law school, they think they know everything under the sun. That's not the case. There's always something new to learn. There's always something you don't know. You know, so get with another lawyer, maybe do a sidebar with the judge, whatever you need to do to get up to speed. I'm Jason Castillo. I'm the Director of Legal Education with Attorney Credits. These are just some points I wanted to mention about e-discovery and our new electronic terrain that we're new practicing in. If you have any more questions, please visit our website. You can reach me at jcastillo@attorneycredits.com. We've got a great blog. We're also on YouTube, if you've noticed here, Facebook, Twitter, so check us out. Ask us the questions that you need. Visit our site if you do need help with these resources. Thank you so much.